Okay, guys, it is 8:30 straight up, and September the 11th, 2018. I can't help but to start out by talking to you guys about 17 years ago. Uh, Never forget that day when I was teaching um, special education, and I was assigned that day to a sub at a grammar school in Illinois, and somebody came rushing into the room and told us about the imminent attack on the World Trade Centers. And someone had a little small TV they brought in, and we stopped teaching, and we all gathered around, students included, and they were very young kids. And I never forget that I saw something that was so surreal that I'll never forget as long as I live. Like the same thing, I'll never forget what I saw when my dad was killed. Um, I saw the first plane hit the building, and I just said, "Oh wow, that plane, whoever's in that plane is dead." Then a few seconds later, the building started to crumble. I just couldn't believe that little plane brought it down. And then while we were still in awe about what happened, then the second plane hit the next building and repeated the same thing. And it was kind of like looking at a movie, or you've seen demonstrations of demolition of buildings when they're demolishing buildings. That's what that reminded us of. But you also saw something else. Um, you saw people. We couldn't determine it was people, but we thought it was debris that was falling out of the building. There were people who were jumping from the building itself, as high up, way up. So it's like many people lost their lives, and the United States has not been the same since that time. Um, Homeland Security was created shortly after that. We went to the period where we had flags that told us on days that we were on high alert, and we went to the point of how everything travel changed as far as airports and all of that kind of stuff. Gradually, attending public events changed. All of that stems from what happened. And then the bad part about situations like that is that we spent probably the next, I know, at least 3 days, probably longer. Every station, everybody just kept playing it. TV programs were interrupted, and it was devastating and pretty bad for everybody involved. But it left a mark, an indelible mark, unlike any other instance. I wasn't born in '41 when Pearl Harbor took place, but I can tell you that this was really something. I remember the closest thing to that prior to the uh, World Trade Center September 11th incident was what took place in Oklahoma City, and the bombing that took place there. That was that's as close as I can get to recalling something, but the epidemic proportion that this September 11th happened again. Uh, some of you guys are very, very, very young, but it's still around. And now you understand, you learn why some of the things are happening now that are happening in this country. So we are wrapping up today. This is the end of the 6 weeks in Introduction to Criminal Law. I tell you, it's a lot of work. I know, having been a criminal lawyer for many, many years, and worked in law enforcement, and have been involved in many areas. I've learned that this is a tedious topic, criminal law. However, it is important that you guys who are working in law enforcement understand what that is all about, so that you find yourselves in situations out there that you are getting what we call a working knowledge. You're going to find this, that I remember one of the toughest courses that I ever had, and I say it, and you know why I say it when I said it, is after I had been practicing law many years and I became the village attorney and police officer. You were required to take so many hours of training, and one of the things that I had to take, and it was kind of like I was sitting there and my arms were folded, and a lot of my colleagues that were in there, they knew, because we were with a bunch of other agencies in there. They said, "Did y'all know that we got a lawyer in the house?" And actually, I found out there was more than one of us in there, and we were all kind of like sitting there smiling every time something was said. And so after a while, the lecturer started saying, whenever they were lecturing on some of the topics in the criminal law sessions, they would refer to us experts, because we were experts, because we were actually practicing or had gone to law school. So the point I'm saying is that, with all due respect to you guys, you have not even scratched the surface of learning about what criminal law is involved, and I would not endeavor to even teach this course the way that I learned it in my criminal law class, but just to give you some clarity on what the materials that you are reading and researching and writing and completing your assignments and so forth. So with that having been said, I'm going to make some parting comments at the end. Let's get into this week. All right, let's share my screen here. Okay, here we go. Okay, let's move this out of the way a little bit if I can. Here we go. All right, so you see my information in the corner, and then you come all the way down. I'm skipping over all this extra stuff, bringing you down to the fact that this is week 6, the final lecture, and that it will be recorded and, of course, placed down here as usual, so you know about that. Plus, I email you the link as well. This announcement here you can disregard for this class, because it says WebEx live lectures will be unavailable Friday the 14th. I know Friday the 14th is our last day of class, but it doesn't affect you, because number one, I will be uploading and converting these to MP4s to YouTube, and on YouTube you will be able to see them without any interference from what is happening on WebEx. So you won't have that issue. I said that other weeks before too, so you know, be aware, so you can still get your points. So now let's take a look at our final announcement for the course, and let's open it up. There we go. Defenses to criminal liability will be something we'll go over. Chapter 10 of the textbook, mental disorder, insanity defense, involuntary intoxication, mistake of fact, mistake of law, self-defense, and you'll be able to practice with your key terms, and mistake of law, mistake or fact quiz. You'll be able to go over that. I do recommend going over those. Again, I've said that all along, that you want to make sure that you do take time to do those. As I always say to students, the issue is not whether I get credit for doing this. Yeah, you will. You'll get credit because you'll execute your assignments very well and much better because of that knowledge that you have. And so you want to try to do well. Most of you in this class will not be seeing me again in this class. I will be teaching it again next quarter. I was just talking to a student in another class just before I'm here, and he informed me, he says, I have you for 2 more classes next quarter. I said, is that bad or good? He said, no, it's good. I said, okay, good. I feel good about that. So anyway, so you don't want to be in his class with him. And if you are, I'm not going to bust you out. But the point of the matter is you already know if you're in that position who I'm talking to. But the point of the matter is don't get upset because things happen as to why people don't perform well. It has nothing to do with you, but it's how you either manage the time or either how you operated during the course of the adversity that you ran across. So anyway, aside from that, so now your discussion assignment, murder or self-defense, is due tonight, 11:59 p.m. Central Standard Time. Make sure you get those in, and that your initial post is due today, and reply post Friday, which you'll see in the calendar reminding you. Does not go to Saturday. The quiz then is after that, and it is timed. And it says in bold print, highlighted, Friday, September 14th, 2018 is when those assignments are due. So, and then it tells you that the quarter officially ends at 11:59 p.m. Friday the 14th. And then ask you again to take time to complete the evaluations, because I look at those and, see what I did, what I can do better, how you enjoyed the course, or how what could help you to improve this course. I think that overall this 6-week, having taught the 11-week course many times before this, this is my 3rd time, I think, 2nd or 3rd time teaching this one. I enjoy this. I think that they did an excellent job in course development of setting this out. So anyway, in your course, your evaluations, please take time to share that with us. I know you, like most of us, I don't like to do surveys, but this is a survey that will be beneficial in terms of other students that come along after you in this course as well. Now, looking at the calendar again, repeating the reading assignment and everything that you had that I already told you. So you have that. Then your initial post. Then notice Friday, the 14th, your reply post. And then your written assignment, which you know is the quiz, the timed quiz. So you don't have anything to research. All you need to do is study, and we kind of talked about how that's going to play out. You had one earlier, and then this one will be kind of like covering the second half, pretty much. And we're going to talk about what that entails in just a moment here. Okay, so let's go to, we're coming to assignments. Again, tells you about your initial post and reply post. Then your quiz. It's multiple choice questions. It is timed. It's 30 minutes. Okay, and it will. You can be assured. I think I'm right. I would have to look to make sure, but I'm not going to put up because you would be able to see it. I think it's 30 questions. But anyway, the point of the matter is that it's information that you should be fully cognizant of what to do, because you've already gone through the material. Once again, I do provide you with the PowerPoints to use as study tools to help you with each module. to be able to quickly review, so you don't have to go back and read all that stuff in the book all over. Just use the PowerPoints, and then, of course, you listen to the lectures, and so you're good, okay? And then that's it. So I'm excited about week 11 for me. I mean, I say week 11. The reason why is because I teach 11-week classes that end also on Friday, which are 2 of those. But this is 5.5 class. So week 6 is good for me because I don't have a whole lot of grading to do in this class. Basically, all I have to grade is the because it automatically your grade will automatically be submitted after the time run out. Make sure that you're in a place where you can do the quiz. Make sure there's nobody around you to disturb you. Kids are asleep, phones are off. Do whatever you need to do to be able to focus. If you have to go to the library or go somewhere, if you have to go in the basement or someplace, go where make sure you have your internet hooked up and all of that. But you know what I'm saying. So, and I won't be able to let people start their tests all over again, because by the time that I see it, it's not going to be until the quarter is over. So you want to make sure that you abide by that. So there's no rubric to give you, except you know the rubric for discussions, but you guys are familiar with my method for how I look at those. All right. Coming down to our lesson content and talking about things that are involved in this week's topic. Mental disorder, the insanity defense, we're going to touch on that. Involuntary intoxication, mistake of fact, mistake of law, and self-defense. Those are the 4 areas I'm going to cover in my lecture for today. I'm not going to go over the practice stuff or the practice quiz. Again, please, I've said all along, take those practice quizzes. It is so important that you do. You might want to go back to help you prepare for this, is to go back and do your practice quizzes for weeks 4, 5, and then, of course, 6 to help you out, to be ready. So, yeah. Okay, so now, there are many defenses that we lawyers, who are self-defense lawyers, criminal defense lawyers, I should say, utilize. And among the defenses that we, as lawyers say in the business, this is kind of like I've exhausted everything else, or either this is so blatant that I'm going to try to use this as a defense. I'll give you a hypothetical. It's not really a hypothetical, it's a real case. I represented a young man who was never in trouble before, stayed out of trouble. He was 17 at the time this offense happened. The young lady came to his house to turn on the gas, not to shut it off, but to turn it on, and he was the only one home. Well, as it turned out, and this is all based on information that came out in the case and in my discovery when I filed motions to get statements that he had made. And so anyway, it came out that this young man had this young lady there, and that he was sitting there while she went down to light the pilot there, and when she bent over, she was wearing pants. He said he just lost it. He did something he had never done before. The kid didn't even have so much as a detention in school. He grabbed her and he sexually assaulted her. And then after he sexually assaulted her, he tied her up, and he says, "You're not going to tell, are you?" This all came out. "You're not going to tell, are you? You're not going to tell." And he said, "You're not going to tell." Well, anyway, he said, "Yes, you are." He was answering himself. And he had a knife, and he took the knife and he began to poke her. until the blood started coming. Then he saw more blood, and the more blood he saw, the more he poked her. Well, he stabbed her multiple times, and she bled to death and died. He then took the bloody underwear, hid them under his mattress. He took the body out of the house, put her in a garbage can in his garage. He rolled the garbage can a few blocks away and left the body there. And the first time I discovered it is I was looking at TV and I saw, you know, the police talked about what happened. They discovered this body. So anyway, next thing I know, they arrest this young man. And when they arrested him, I get a phone call from his mother. I never knew her. She knew me because I was on the radio at the time. And by the way, I'm going to be back on the radio again starting Friday. But anyway, she retained my services and I became his attorney. And so what I did was I did what we lawyers do first. I filed my motions for discovery, seeking to get the reports and everything that were involved, statements and so forth. And in the context of all of that, I filed various motions. And I filed a motion saying, wow, this kid never been in trouble. He never did anything. At the time, he said he had lost control. So I was obligated to file a motion to have this young man examined by the psychiatrist that handled them. His family wasn't wealthy enough to be able to afford a private psychologist, so we had to use the one, which we would have used anyway. And so the psychologist came back with the report, psychiatrist, that at the time he committed the offense, that he knew what he was doing, that he understood what he was doing, even though it was crazy and bad. His mind may have not been functioning properly, but it wasn't at the level that would satisfy the insanity defense. And one of the problems that happens in the insanity defense is that individuals, if they have any kind of planning after the incident happens, then they pretty much are looked at as they knew they did something wrong and they were trying to cover it up. That meant they weren't insane. The definition of insanity in our jurisdiction is pretty much a person who was unaware at the time they committed the offense of what they were doing was wrong. This guy already knew. His statements buried him, and then also his actions after that. So the insanity defense is one that I can tell you in my career as a criminal defense lawyer, I, like many of my colleagues, was never able to get that defense in. We tried it, we did it, but it didn't happen. So having given you an example of how it works, I'm going to now go through and explain a little bit about how it works here. So an individual is, as it says, presumed innocent until they are proven beyond a reasonable doubt that they are guilty of the offense. But in a insanity defense, one of the first things that happens is that the defendant admits that they committed an act, but that at the time that they committed the act, they're not held responsible because they raise what we call an affirmative defense. Affirmative defense is a defense that comes from the defense to defend the actions of the individual. And so insanity is one of the affirmative defenses, just like you're going to hear me talk about later, self-defense, meaning I did it, but it was justifiable. Now, in this case, it's not justifiable, but what is being said is that the person was not capable at the time the offense took place of appreciating the criminality of the act that they were committing. That's the thing that really has to be done. And so we call them excuse defenses or justification defenses. But for the fact that my mind was diseased at the time, that's what we pretty much say, that it wasn't capable of functioning in a proper fashion. Therefore, I should be found not guilty by reason of insanity. Now, what happens, just again, jumping ahead, is that if a person is deemed to be insane at the time of the offense, that individual doesn't just walk out of jail. They walk into a health, and they're put into a facility for the criminally insane, and they deal with it from that. So for all practical purposes, using the defense keeps them from being incarcerated in the, quote, traditional sense. However, be aware that unfortunately, because of the budgetary issues, these individuals don't have the proper resources to take care of them, and a lot of times they're exposed to other hardened criminals. So having said all of that, now you got a good picture of how this works. So the insanity defense, again, it says that had must prove that the mind was guilty, premeditation, knowingly or intently committing an act was a crime. But then the defense says, I know I did wrong, but I didn't possess the mental capacity at the time of the offense, period. So insanity is the top of the ladder. There's a thing later called diminished capacity, which is something that I'll touch on. Well, I'll say it now. Diminished capacity means what it says. It means I might not have reached the stage where I was mentally ill at the time, adequate enough to use the insanity defense, but that my judgment was impaired by something. And what it is used generally is a mitigating circumstance once a person is sentenced. It's not used to exonerate that individual at all. So insanity, it says, is the most recognized affirmative defense. However, it's not something that gets you out. Doesn't mean, as I said, you walk out the courtroom, but instead, when the jury returns a verdict that you're not guilty by reason of insanity, then you're committed to a mental institution. So the bottom line is that your freedom is taken away. Okay. Now, most states, except Idaho, Kansas, Montana, and Utah, don't allow for that. But verdicts, in these states, if a person is determined to be not guilty, then the defendant is committed until they are sane. So basically, you can't play this thing because you'll be there forever. So there are three types of basic approaches that we're going to discuss. There are some others: the Norton rule, the Durham rule, and the substantial capacity test. And jurisdictions vary. Some have a combination of them. But let's go one by one. So let's talk about the Norton rule. It looks like it says M. Norton, but it's called the Norton rule, which goes back to where our law originally started and came out of England. And if at the time they commit the offense, the mind was diseased and prevented the individual from recognizing right from wrong. That's pretty much what it was. And so it was called the right-wrong test. And they give examples here that at the time of murder, the defendant thought that they were stabbing someone with a knife. He thought the knife was a straw. Or you could be of a state of mind where you were stabbing someone with a knife, but you thought you were stabbing a pig or an animal as opposed to a human being, and that your mind actually conceived that, and that you were actually doing that. Or at the time of the murder, you knew you were stabbing someone, but you thought that nothing was wrong with it, killing the victim. Again, like I said, your processes didn't make sense in terms of your actions. However, it is not an easy burden to come up with. Look at what the state of Florida, which says that all people are presumed to be sane. That's an interesting thing. But anyway, an insanity is a defense that must be established that took place, as I said, the key is at the time of the offense. The defendant had mental infirmity, disease, defect, and because of that, the defendant didn't know or couldn't appreciate the consequences of their actions. Or although the defendant knew what he was doing or she was doing and its consequences, didn't know what they were doing was wrong. So it's kind of like give and take here. The bottom line is, in the Norton rule, you right from wrong is something that you're taught from day one as a kid, good and bad, but it's taken away from you at the time of the offense. If the prosecution, if the defense can prove that that was the case, and it takes a whole lot of factors, then you do that. So that's the Norton rule. The Durham rule is only in one jurisdiction, New Hampshire. And this is what they call the product of mental illness test, or the product of the disease mind, is the way we used to talk about it in law school. And so the mental defect excuses the act itself. So it says that but for the fact that you had this mental defect, it almost sounds like the other one, but it's different, because what it applies here is that the right, if you look at the case that established the Durham rule, it was 1954, when I was only 4 years old and most of you weren't born, said that the right-wrong Norton rule was simple. Said that mental illness was very complex, which we have to agree. It's more than just right or wrong, and that there has to be some intervening factor that caused that to happen. Not drugs, not alcohol, but there's some issue in the mind, so the mind doesn't function. Oh, I'm doing this, I shouldn't be doing this, that's wrong. So it actually is easier to prove than a Norton test, and it deals especially with the one sole question, and it says it right here, and I remember this well, is that the purely intellectual question is, did the defendant know the difference between right and wrong? That is expressed in Norton. So it stretches it more to the disease mind aspect of it. So, and the reason why they didn't know right from wrong is because they had a diseased mind. That's all. That's the Durham test. Okay. It's interesting when you look at both of these two tests I've talked about so far. One of the things that should come to mind to you is that, well, shoot, that's like basic stuff that you're taught from a kid. But what we're trying to say here in these instances for these first two, the Durham and the Norton test, is that there's been some intervening activities that has short-circuited the ability to communicate the left side with the right side of the brain, or this. Let me put it to you like this. Okay, a light bulb comes on because if you ever look at a bulb, it has what we call filaments in there. You've seen the little parts of wires that are in there. And when they break, we say that the light bulb doesn't work anymore, because it won't. And then actually you'll shake it and you'll see it. Though the filaments connect one side to another, but for that happening, there's no light. Well, that's the same thing here. The brain is connected to the right things to do and the wrong things to do, but there's a break in there, and it doesn't complete the communication into the actions of the individual. Therefore, they have a diseased mind, or they don't know right from wrong. That's it. That's it. That's it in a nutshell. It's no deeper than that, but that's really what it is. So then we come to the substantial capacity test, which is pretty much where a lot of jurisdictions are, including ours. Illinois, the substantial capacity test came out of the model penal code. And whenever you hear things like the model penal code or the model this, what it's saying is that experts got together and they came up with something to unify, attempt to unify a method of dealing with an issue. And so their main objective with the substantial capacity test was to say, we got the Norton rule, we don't need to do that. And so the right, different from right and wrong, that's like, duh, but rather because the person had a mental disease or lacked what we call substantial capacity to appreciate the wrong thing of their conduct, you prove that, then you've met the substantial capacity test. So you might be sitting here saying, well, wait a minute. Isn't that kind of like the same as the Durham test, which deals with the mental disease? Kind of, because it was moving more towards that. But the fact of the matter is that the wrongfulness of their conduct did not eliminated their ability to obey the law, period. So an example here in the state of Wisconsin makes it kind of clear. A person is not responsible for criminal conduct if at the time of such conduct, as a result of mental disease, whatever that is. And mental disease might be laid out and explain some examples of mental disease. Or defect that the person didn't have substantial capacity. There we go. I told you that's what the deal was in terms of this whole thing. Substantial capacity, either to appreciate the wrongfulness of their conduct or conform to the requirements of the law. So it's kind of like, well, what's the difference? It's not really a big difference, but the effect of the whole thing is that the individual is thought, everybody is presumed to be sane. I know you do crazy stuff happens, say, boy, that's insane. That's just a figure of speech. But the burden on the defendant, because it's an affirmative defense, has to prove that at the time of the crime, not later. And so the states vary the burden of proof to be successful in the insanity defense. And it's not beyond a reasonable doubt, but the standard is preponderance of the evidence or clear and convincing evidence, or the circumstances make it pretty clear and convincing that that person was suffering from a mental disease. That's pretty much how it operates. So a separate hearing is held to determine first if that person is. And you've heard of situations where people are determined that they're not sane enough to, not at the offense, but even to withstand trial. And then they'll put them in a hospital and those kind of things. So the key thing to remember is that while these are defenses to the crime, that doesn't mean that you don't have consequences that take place. And so you have experts to come in. Some people bring in their psychologists or psychiatrists. And then, like I said, again, in my case, the family couldn't afford their own because they're very expensive. And they'll provide their expert opinions to the court. And so the judge, in some cases, the jury will make a decision depending on whether it's a bench or a jury trial as to whether or not the person is insane or competent. If the person is deemed insane, then they'll be ordered to a mental facility until they're deemed no longer mentally ill or dangerous, which means it could be a life sentence, basically. And it's kind of interesting. Who wants to fake that? Nobody pretty much does, especially if they're in a jurisdiction where there is no death penalty, okay, and the person doesn't qualify. My client in that case didn't qualify for the death penalty because in our jurisdiction, and this was prior to the Simons case, which says we don't execute juveniles, and that so as a result, what happens is that this individual would be eligible for a life sentence if they were found guilty, which is actually, as I tried to cut a deal for the young man, they didn't accept it, and he ended up going to jail for the natural life and will be there forever. But anyway, the point of the matter is so these people aren't really, they don't have a basis for trying to say, okay, I'm going to pretend I'm insane because it's going to benefit me. Not necessarily. You could be shooting yourself in the foot because you could be found entirely not guilty in a stretch, but you remove that once you get to that particular point because you're going somewhere other than home if you are determined to be insane. So that's the insanity defense. Very rarely successful, but it's still a requirement that we lawyers still do in terms of providing defense. The next affirmative defense, whenever I say affirmative defense, it's a defense that's raised by the defense. And by you saying affirm, that means that you're stating that you did do the offense, but you have a reason that stopped you. Intoxication. Now, be aware that intoxication is very, 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 very good if you can prove involuntary. It has to be involuntary. And in most jurisdictions, including ours, it is a situation where the person is intoxicated without their intentions. So they weren't drinking to get high or something like that. Maybe somebody put a Mickey in their drink or something. Maybe they put them on a trip by dropping something in their drink, and then they did something. So anyway, it says is that it is only if the intoxicated was involuntarily caused. In other words, the person can't themselves drink and become intoxicated and then say, no, it's not, that ain't going to fly. Even if you're an alcoholic, it's still not going to be satisfactory. So here's some examples from Michigan and Kansas that really kind of lay it out. And I like these because they did a good job of putting these in. It says in the statute in the state of Michigan that under the influence or impairment by alcohol or drug defense is prohibited except if it is an affirmative defense to a specific intent crime for which the defendant has the burden of proof by a preponderance of the evidence. Remember, we're getting back to the same thing we talked about with the insanity, and that they voluntarily, by preponderance of evidence, that he or she voluntarily consumed, legally obtained, and properly used medication or other substance and did not know or reasonably should not have known. Because remember, there are warnings on there. So if you ignore those warnings, then that doesn't exonerate you because you should have read it or should have known. That would become intoxicated. In that case, you're not going to be successful. So it's a very difficult burden to prove. Kansas says that a person charged with a crime is intoxicated at the time. Remember, it's always got to be at the time of the offense, not at the time of trial. If they involuntarily produce and rendered such person substantially incapable of knowing or understanding the wrongfulness of their act, sounds almost like the insanity, and of conforming such person's conduct to the requirements of law. Basically, what they're saying is that the drug or alcohol, whatever, is involuntarily ingested, then in that situation, they commit an offense, then in that case, then they can use that as an affirmative defense and be successful. So it says that it can be applied in those cases where criminal law was violated, and that prerequisite of the element of intent, or as we call mens rea, is required for the offense. For example, if the person didn't know the difference between right or wrong, you know what that sounds like. And the fact that the person was involuntarily intoxicated negates their ability to meet the elements of the crime. So you got two parts, not knowing and involuntariness. Those are the elements. Involuntariness is first, though. So, and then it gives some examples that I just got through talking about a few minutes ago. It says, for example, a college student, Jim, had been up partying all night, but has to take a test the next day and doesn't want to fall asleep. A fellow inmate offered him a white pill and says it's a caffeine over-the-counter drug and it helped him keep up. However, the person lied to them, and the pill was actually a methamphetamine hydrochloride pill, and that Jim had an adverse effect to it, caused the person to panic and rage. And while in this stage, he breaks the windows of a store, destroys merchandise. The police arrive, arrest him. In other words, he was out of control. And so Jim has to prove that he was involuntarily intoxicated. He could be found not. He may be found not guilty of vandalism or disorderly. So that's the kind of thing in a nutshell. So you get it. You get it from there. It's pretty clear there. So now we move into the area of, we got two areas, mistake of fact, and then we're going to conclude with self-defense and use of force and stuff like that in the next few minutes. So what's mistake of fact? It kind of describes in itself the name. It happens when someone commits a crime but didn't understand the fact that negated an element of the crime. Now, of course, ignorance of the law is no excuse. That's an old adage. But it says here in Missouri, ignorance and mistake states that a person is not, you got to make sure you read every word, not is relieved, but is not relieved of criminal liability for conduct because they engage in such conduct under a mistake or belief that it was legal. So under Missouri law, like most states, including ours, the defense can be claimed if the mistaken action is related to an element of the law in question. So let's look at this example. Makes it pretty clear. This is a mistake of fact. Lisa is making a large purchase at a home goods store, including a push mower that's in a large box, which she puts on the bottom of her cart. The top of her cart is filled with other items. While paying for all her items, she distracted and doesn't pay attention to the clerk to ensure that the items are scanned. So she pays the bill with her debit card and leaves the store. Now, after she leaves the store, then she's stopped in the parking lot by the loss prevention officer who says you didn't pay for the lawnmower. So the loss prevention officer doesn't even give her a chance to say, oh, I'm sorry, I made a mistake. That's, I call them, I says, okay, sometimes I not offending loss prevention officers, but sometimes people get a little carried away there. So the loss prevention officer calls the police and requests that Lisa be charged with theft. Now, she'd say, well, wait a minute, I didn't do this on purpose. She said, because I intended to pay. But the clerk neglected to scan the lawnmower. And the reason is because she didn't bring it to the clerk's attention, but she wasn't trying to, she didn't have the state of mind to commit a crime. So her testimony or statements of that, and then probably she could bring in people who know her and those kind of things. The bottom line is this, is that it would seem pretty clear that this is a situation. I I know we go to the store, Walmart, and we buy water, a case of water, and we'll have groceries on top, in the basket, and then under that we'll have like the case of water, and then you guys know what I'm talking about. And you will have the person ring out, ring out. Well, we will usually say to the person, "Oh, don't forget there's water under there." But let's say we're distracted and we're talking and so forth and so on, and then we go out, and those people at the front don't stop you all the time. And like the people know us at our Walmart, so they don't bother. They just, "Hey, how you doing?" And they might even remember our names, but they know our faces because we're regular customers. The point of the matter is that if we had water under there and we got outside, then it would be like, we might not even realize it. But do most people, when they go home, go over their receipts to see if there's everything on there was paid for? No, it doesn't. And so what ends up happening is that if you're not stopped by, because if they stopped us at the front and says, "This is not on your receipt," we say, "Oh, I'm sorry, apologize," and then go back. Now that person could be a jerk and say, "No, technically you didn't pay for it, and so you're on the other side of the counter. That meant that you were trying to steal it." Well, no, now you're trying to go into my state of mind. I'm a professor at the college teaching criminal justice. Do you think I want to steal a case of water? I don't think so. But anyway, that's what I'm trying to get across to you. So you got to use a little common sense in terms of looking at that aspect. So that's mistake of fact. Okay, mistake of law is a little more involved. If a person violated the law, but they thought at the time their acts were legal. Now, listen to me. It's not the same as ignorance of the law. Right up front, I want to say that to you, because people say, "I thought you just said ignorance of the law is no excuse." I did, and I'm not taking it back. But it can be involved in some of these cases, like some of these examples to clarify it. A person operates on the basis of a law, and then the law is later found to be unconstitutional. Well, that's because the law had to be challenged and tested, and on appeal, it says, "Oh no, that law is unconstitutional." So that person didn't violate you don't violate an unconstitutional law, but you don't know it's unconstitutional until it's been brought to a court that's higher than the bench trial, or the court of what we call the trial de novo, which is the first trial in Latin. And so as a result, it goes to appeal. Then the appellate court says, "Oh no, that's a violation of," and they'll tie it to your state constitution and or the federal constitution. So if it's unconstitutional, the person acted in good faith with a judicial opinion but didn't apply it. So in other words, argued a point of law, and it didn't really apply, but they were trying to make it apply and not just stretching it way out there. Okay, but that's an example of mistake of law that the person can say they relied on the law. That's basically, it's a reliance on the law. The third is a person acted upon the advice given by a person or agency responsible for administering law, such as a police officer. Now, if your attorney advises you of something and you do it, then that may or may not apply. But when it says an agency responsible for administering the law, we're talking about the judges, the lawyers, the judges, the prosecutors. We're talking about probably even the public defender, but primarily in this instance, we're talking about on the streets, the police officers. So that can be a mistake of law. A person committed an act contrary to the law that has yet to be published. So it's not a law yet until it's made known to the party. So then they can argue the fact that the law was made after the fact, and that law is deemed not to be legal and can't be applied. So in some state statutes, North Carolina, for example, mistake of law states that a person, good faith, notice that fits within the context of everything I've said, doesn't constitute a crime and can be an affirmative defense if they acted reasonably upon statements contained in a statute, a judicial opinion, decision, a administrative order or law, or an official interpretation of a public servant or person charged with responsibility, like a police officer or something like that. So it is really not used a lot, and like I said again, ignorance is not the point, but it's based on the whole good faith reliance upon thinking that you were really following the law, and that's kind of like that. So, all right, so I'm not going to go over Paul's example because we're running out of time here, but you get the idea of what I'm talking about. So self-defense. One of the most widely used examples, I've won many cases using that, including my very first case, which was a double murder using self-defense. And so the issue is that the actions of the individual are justified based upon all the surrounding circumstances. And so basically, a person who is under attack, or someone is under attack, or to protect a person, they use the commensurate force to stop someone from going further. So the point of the matter is, in a nutshell, and I'm not going to go over all these different scenarios here, the point of the matter is that if someone raises their hand to you to hit you and you take out a gun and shoot them, then you're probably not going to be able to use self-defense. You might not be able to use self-defense if that person has hit you or done something to you and then they're running off, unless they have a weapon or something like that. Now I'm jumping into something else. But the point of the matter is that it must be reasonable under the circumstances. Let me just show you what Illinois says. A person is justified to use of force against another when, to the extent that they reasonably, notice that you get into the reasonableness application, that the conduct is necessary to defend himself or another against imminent unlawful force. However, that person is also justified in using force which is intended to cause death or great bodily harm only if they reasonably believe that such force is necessary to prevent the imminent death or great bodily harm to himself or another. So basically, what you're doing is protecting. It is self-defense. It means what it says. So, and it talks about in the example above that if it is apparent that Bob's initial use of force was justified. However, Bob committed great bodily harm when he beat the person in the unconscious. So in other words, you can start out right, but go too far. And that's the whole issue in a nutshell. And in most states in the country, a person is required to retreat. However, that's changing. That's changed. Now, stand your ground, which Florida became famous because of the Trayvon Martin case, and Florida became like the poster board for the stand your ground. Doesn't require a person to retreat. And so that's catching fire across the country. As long as they are not engaged in unlawful activity and have the right to be present where the incident occurred. So individuals can't assert a stand your ground if they're committing a crime when they are attacked. So it deals with the duty to retreat issue, but in some states, the duty to retreat means, and you know, we've always argued as lawyers, why impose upon the individual before they take the steps to protect themselves that they use a way of escape, because they can get hurt themselves or killed trying to escape or get out of the way. And so that's the argument that has caused jurisdictions to move toward the stand your ground law. If you provoke the attack, you can't use it either as well. So so take a look and see, you know, what you find out in terms of that as well. The battered woman syndrome, very simply stated, is this: a woman who will commit an act of killing someone or seriously hurting them because they have been the victim of being beaten by that individual in a marriage or in some kind of relationship. In that case, it's used to justify the killer. And it's used in murder cases. I know a young lady who was the victim of, in Illinois, she was a good friend from high school, and I didn't represent her, but they brought me the file after that and wanted to know if I would look at it. I told them I didn't do appeals. But anyway, I looked at the whole transcripts from the hearings and saw what they were trying to do is that she waited for her husband to go to sleep and then shot him. That negated the battered women syndrome issue. So she had some planning involved. It's usually considered as a heat of passion type of response to someone beating you. But in domestic abuse cases where I said it pretty much, they're in constant state of imminent danger. And so as a result, they resort to using violence or sometimes deadly force. So it's what's happened. But I can tell you this, that if I had probably represented this young lady, I believe I could have gotten her off with a jury. The person had a jury, but he didn't do a good job of getting the jury. Let me say this to you, that you'd be amazed at men and women on the jury will find for this, especially in our domestic violence era now, that we have brought attention to that type of thing that's happening. Kind of like the same thing with the sexual issue. I forgot what it's called. Not me now. I can't think of it. But it's the same kind of thing that applies here. That came out after Harvey Weinstein, you know, with the sexual things. But if you know it, then you can type it and let me know. But I'm drawing a blank on it. But you know what I'm talking about. So the point of the matter is that Me Too. Okay, yeah, I was kind of on it there. Yeah, thank you. Yeah, Me Too. That kind of thing. So that movement, same kind of thing occurred with dealing with the domestic violence issue, particularly with men on women. But now it's applying to men on men, women on women, and so forth and so on. So you can look at this video, you get a chance to, and you can see that there. Okay. So now let's get down to, well, the castle doctrine permits people who occupy within their dwelling to use deadly force to stop intrusion. And it's called the castle just because your home is supposed to be your castle. That came from the old British statement and so forth. You know, you're supposed to be able to be secure there. And so it says that you can use force in necessary to kill an individual in your residence or dwelling or occupied vehicle. So anyway, that's what the castle doctrine is pretty much about. And I'm just saying on that, it's important, as it says down here at the bottom, to note that this deadly force privilege only applies when the dwelling is occupied. Can't argue that if you're not occupied. So if the homeowner's at work and sees a burglary inside his home on a closed circuit surveillance system, they can't drive home and use the castle doctrine. You had to have been there at the time. And oftentimes it's used when people are asleep or at home and somebody breaks in while they're there. And that's pretty much what that operates. So then that allows you to take the life of that individual. And so we're going to conclude by saying that police officers are caught up in more and more and more excessive force cases. And the instance of police officers now are with the standards, you can use reasonable force to arrest a person, for example, hitting a suspect with a baton, taking them into custody, will cause bodily harm or even substantial harm. Just so the force is reasonable to make the arrest, the officer will not be charged with battery. In contrast, similar force applied by a citizen would be considered battery. Now, the force is going to be subjected to heavy review and oversight by agencies, which most departments have now. And deadly force is most highly scrutinized because everybody's got cameras now, okay? And then you got the body cams and you have the dash cams, and everybody has cell phones now with cams. Not to mention the cameras that are up at the street lights and things like that, and most organizations or institutions have cameras also. Like, for example, where I live in our parking lot, there's one. If you go to stores like Walmart or those, they have them as well. So highly scrutinized because the death of a person is a result. So the use of deadly force is supposed to be rare, and police officers show great restraint when dealing with deadly force situations. And so there's a whole issue that's taking place, and it's up for debate. You have arguments on both sides. Now, let me say this, that something just came out of Chicago, which is very interesting, that and this is an attempt to deal with deadly force. We have a case coming up called the Laquan McDonald case, where the officer has been, as rarely happens, charged with murder. And we just had one I just heard about down in Dallas as well. But here's the point of the matter is that police officers are now, it happened out in North Carolina with Walter Scott case, where you saw the video that showed the person was running and the person was shot in the back by the police officer several times, and then the officer was caught on video trying to plant a gun or something. So that person is being tried. But here's my whole point in a nutshell. So what Chicago is doing, and the Fraternal Order of Police, and which is like the union for the police, they're trying to fight it, is that every time the police officers pull a gun out of their holster and point it at someone, they have to document that. They don't have to fire it or any of that. And so there is an argument being made by the police that this is going to put a chilling effect on them because they don't want to have to go through all of that. And they don't want to be subjected to reviews and spending time and under boards and all that kind of stuff, checking out what they do. But I want you to understand something. The reason why this requirement came out is because of the litigation that takes place where the municipality ends up spending millions, not thousands of dollars, to pay individuals in cases where there are alleged excessive force is used. So it's going to be interesting. This is in Chicago. You can probably check do some Googling and research and say, we don't know where it's going to go. We don't know what it's going to take, where it's going to end up in court. Right now, it's a policy that is in the department. And how many of you know already that one of the things, if you become a police officer, you have to make sure that you follow the requirements of the agency that you work for. And so many departments, because of the litigious situation, is going to these kinds of extents to try to minimize them. So again, There are police officers that I know have said some are cool with it. Others have said, well, you know, it's been common knowledge that if your weapon goes off, even if it goes off accidentally, you got to write paperwork. You got so much paperwork to do that when you fire. But I can say this to you. Because of all that paperwork, it didn't stop police officers from firing their guns when they felt they needed to. So my point is this. In this situation where the guns are pointed, is it going to tell police officers not to point guns? No, because here's the whole idea in a nutshell is that you must be able to justify your actions even if you're a police officer, which is very important to restoring faith with the community. And there's some real serious issues that law enforcement particularly is under because of these excessive force cases. And actually, there are people who are African Americans who are really concerned when they're stopped by the police. Doesn't matter what race of the police officer, just because of some of the things that have happened, like the Orlando Castile in Minnesota, the Freddie Gray down in Ferguson, I forget the young man's name in New York, who they say he said he couldn't breathe, and I think his name was Freddie Gray. I think that was Freddie Gray. But anyway, the point of the matter is, all of these types of things are so Eric Garner. Thank you. That's who it is. Thank you so much. And so all of these are things that the individuals are looked at. So that's pretty much it with the self-defense. The Second Amendment talks about stopping people and detaining them for no legal reason and all those kind of things. So you can learn more by looking at these clips. So I'm going to adjourn by simply saying that it's been a, make sure you go over these key terms to get ready, to say it's been a pleasure to have been your instructor for the last 6 weeks, 5.5 weeks. I hope that you've learned from my experiences and from the examples I can give you from my representation of individuals, being on all sides of it, to be able to get you to understand. But again, it is a lot of work in this course, but it is essential. It's necessary that when you're out there, particularly if you're in law enforcement, that you understand the rights of individuals so that you aren't opening your department up for lawsuits and or you're basically, as a person who's carrying a badge, operating under what we call color of law, given the ability to be able to know the rights that people are entitled to, and that you want to do your job well, but you also want to be able to satisfy the requirements of the Constitution. Not everybody likes it. Like, for example, the Miranda issue. You know, I can tell you this, is that as a defense lawyer, I've told many of my colleagues, and they understood it, that the law is not to protect the defendant. The law is to protect the rights of everybody, and that's the whole key thing. And that even individuals who are charged with crimes are individuals who have rights, and you got to do it the right way. You can't just the Dirty Harry, Clint Eastwood kicking in the door type stuff. That ain't it. That ain't gonna get it. So you want to make sure that you understand these rules and abide by them. So I am going to leave you, and I know some of you I'll see again in other courses down the road. There's a few people I know that are going to be taking contemporary issues of criminal justice. I will be teaching that course next quarter as well. I'm teaching it now. Some of you, Introduction to Corrections. Some of you I'll be seeing later on. I haven't taught it for a while, but sometimes I teach evidence and criminal law. I mean, also constitutional law as well, those kind of things. So you may see me in some of those things. So with that, I'm going to give you one phrase, and that is self-defense. Self-defense is what I need you to give me for your final points. And I wish you the best. And again, thank you for taking this class. Please, I encourage you, please complete the survey at the end. Let me know what you liked that I did. Let me know what you didn't like that I did. Don't talk to me about that's just one student. I get okay reviews, but I got sometimes students, and I don't know who it is, but one student basically told on themselves in the report based upon the circumstances that they were under, and they were upset because I didn't give them the ability to be able to do extra work. And I said, I don't do assigned extra work. I can't. I got 130-something students. I got to grade all these papers. So anyway, next Monday, your grades will be submitted, and they have to be submitted by Tuesday morning. Sometimes they let us have a little longer, but I will have them finished probably by Sunday night. So good night, and see you again. Thank you. Thank you. My pleasure. Thank you again. My consummate student who's there, I think, been there every week. I think every week. I think, and I hope that. Oh, and I will say this to you. This I'll say at the end. I encourage students to not just listen to the lecture to get the points, but I also encourage students to come because it's something about being there to hear it live and then listening to the lecture that you get a whole lot more contemporaneously. That's like when I'm trying, if I try to tell you something, and then you send me a message. Thank you. You send a message saying, in an email, I want you to do such thing, and then I respond to you in email. Then I'll say, wait a minute, this is not too cool. Let's get on the phone and talk. Well, the next best thing in here is not to listen to the lecture or the archive, but to come. And I can tell you that my students, I really, it's close to 100% of my students who come to the lectures, live lectures, their grades are up there, and they're usually our honor roll or dean's list students, and they perform very well. There's a correlation between that live thing. Just remember, before this stuff all happened, we were in the room together, and as a result, you were able to. And I was like a lion tamer in the classroom. If I saw a student doing something that they weren't supposed to do, I didn't bust them out. I did kind of. I would walk over by where they were and continue talking. And then what would happen is everybody would look over there, and then the person would come to me later and says, you didn't have to do that to me. I said, yes, I did. I said, because you were doing your nails while I'm talking about something, or you were on your cell phone, and you weren't supposed to be on your cell phone, or you know what I'm saying. So anyway, you could do what we call distracted learning. Sometimes people do that with these live lectures. They'll lock in, and then if I ask a question, they'll come back and say, I'm sorry, what was the question you asked again? I asked them what was their name and something like that. So that meant that they weren't listening. But anyway, you got me. So I take the time to do these. I'm required to do these for these 5.5. I have no problem with it. I love it, enjoy it. I have fun doing it. I hope you have fun as well. So good night. Have a good break, and I hope to see you guys further down the road. So I'm going to stop sharing, and then I am going to exit. Okay.